it's also a feature that distinguishes this being like a regular court. So you have that advantage of saving time and then saving cost, and then having quick resolution of matters that are brought before it within stated period. I think I also heard because there are two levels to this court. It would appear to me that what I heard, that means there would be a magistrate, that's the magistrate level, that within 30 days they should determine the matter. So if the appellate level to the High Court within 60 days should be determined. So this kind of specialized courts have this time frame as well to entertain a matter, to determine a matter, as distinguished from regular courts that they have a longer period. Take, for instance, if you finish hearing a matter at the end of final address in the regular court, the judge has as long as within 90 days to deliver judgment. He has the freedom within 90 days. That's about 3 months to deliver judgment. But you will have this specialized court to say within 7 days, within 14 days as the case may be, or whatever stipulated period, you must deliver judgment upon conclusion of hearing. These are some of the special features. And then the rules are usually relaxed a bit. And again, there's also this service issues that definitely will be time frame within which period you must do everything. No, it is in the regular courts as well, but the period could be shortened to a reasonable extent.
What kinds of matters can be brought before a small claims court?
Apparently, there are civil matters, commercial matters, matters that you're going for. Okay, yes. This will require for me to explain something. It must be a liquidated sum that you're going to pursue. And then a liquidated sum will mean a sum that's ascertainable. It is known, it is definite. It's not going to be subject to any calculation or any imagination at all. So that is so straightforward. I supplied you 1 carton of Indomie or a noodle, and then it is 500 naira, and you haven't paid me. And so you know that this is the definite amount that you are pursuing. So it requires a kind of certainty, ascertainment of that amount. That makes it a liquidated money demand or claim. But so that you don't have the controversies of having to calculate and imagine imaginary profits and all of those kind of things, you would go to the regular court. So the nature of matters that will come here generally are simple civil claims, commercial transactions, that the claims are quite ascertainable and clear and undisputable really at all. I don't expect criminal jurisdiction in this kind of regular courts. They really are not.
Now, let's go back to the issue of the expeditiousness of the small claims court, which is, you said, to borrow the expression, I think, is one of the special features of the small claims court. Now, going back to the Judge Judy example I gave a while ago, sometimes when you watch an edition of Judge Judy and one episode, you find 3-4 matters attended to, and each matter is attended to in a matter of minutes. And the Judge Judy simply already has a brief of what the petition is, and or the claim, and it is a counterclaim. She has a brief also. Then she simply asks questions. What did this happen? Tell me what the defendant, on what date this happened, what say, and then ask another question. She is something that needs the attention, she attends to it, otherwise tracks it out. So the entire thing is done with. Even matters that reach the threshold of $5,000 are expended with in a matter of minutes. Now that sounds to me, or that seems to be like expeditious is very much a watchword in those matters. So when we're saying 60 days, because from the story I read a while ago, it says a small claims court with a mandate of resolving every small commercial dispute within a period of 60 days from the date of filing. Doesn't that call into question the seeming expeditious nature of these small claims courts in Rivers State?
No, it doesn't. That you have that proclaimed thinking about Judy that can happen. They can dispense of a matter the same day, and let it be said that the fast track of this kind of specialized court is such that you could even hear matters every day. The regular administration of and also days could put a regular and have an adjournment for every month. So you were in court the last time about a month ago, and the next time coming to court a month. But these specialized courts have given day-to-day adjournments. So it's possible that in a single remote claims court can dispense a requirement that with the small claims court beyond 30 days. That's what it actually means. So it means that it can be dispensed with within a day, within 2 days, within 1 week, and then it was not exceed 30 days. If anything that's going to get to appeal, then beginning from the first date of commencement of that action and until until the dispensing of that matter at appeal. It must not exceed 60 days. That's what actually it means. So it is quite expectant, really, that the fast track objective could be such that matters can be determined in a day. And the implication of the rules of evidence and even the legalese and all of that. As a matter of fact, self-representation is encouraged in this kind of specialized court. So even the businessman can, because it's simple, it's made simple really, and quite interactive. Just like you're saying now, the judge we would see in the semblance of Judge Judy will be interacting with the litigants. It doesn't quite happen this way in the regular court. The judge doesn't descend that much into the arena of conflict between litigants in a regular court. So you just observe and technically observe some aspects of the matter when you can't help. But this kind of small scale, small claims courts and specialized courts can allow that kind of practice.
All right, I'd like to ask you another question, but I'm not sure there will be time for you to give a response now. But I'll ask nonetheless. Maybe we'll go for a break. When we return, you can give a response to that. Talking about the ease with which a person can approach this court and the simplification of the processes, and how even self-representation is encouraged. Would the litigants need the police in any way to file a matter before a small claims court? Is the question I'd like to ask. Now, are there any processes? Are there any go-betweens? Would I need to approach the police? Would I need to get a lawyer? Would I need to approach the Ministry of Justice or any such thing? But you give a response to that when we return from the break. I still had Factor Nigeria Info and Harry Podhaka. Stick around, we go for a commercial break. We'll return in a moment. Welcome back. It is Hard Factor Nigeria Info and Hearing Pulhaga to number one talk station. I'm Dio. 29 to go before 5 o'clock. The news update is up at 5. Discussions continue, however, for the moment. The River State Judiciary has inaugurated the Judicial Committee on Small Claims Courts with the mandate of resolving every small commercial dispute within the period of 60 days from the day of filing. Chief Judge of the State, Justice Chibuzo Samadamadi, during the inauguration, charged the members to ensure that commercial disputes involving a small amount of money do not last more than expected. He said the move is part of judicial intervention aimed at resolving small commercial disputes speedily. Joining me via phone once again for the conversation, Henry Ekine is a National Legal Advisor with CDHR. Henry, you're welcome back.
Thank you, Tayo, for having me back.
So before the break, I asked a question as to, basically I'm asking how one can access this small claims court, what the procedures and processes will be like. Would I need, for example, to go to a police station to make an entry? And, would I need to, how things are, would I need to pay for entry and things like that? Are there any middlemen or middle persons or middle agencies involved in all of this?
No, not at all. Perhaps except a legal practitioner where you choose to rent the services of a legal practitioner. But you do not need to go to the police because it's a civil action. There is no requirement at any point for making a complaint at the police. So that's completely out of it. The police is not a debt or any arresting authority at that. They are not debt recovery agencies for individuals. And so if you have a civil claim, you simply will have, when the practice direction will be released or the rules will be made public, you simply would have to go to the registry of that court, obtain probably the necessary forms, and then you will be guided and directed as to how to make your complaint. Like I said, it will encourage even self-service kind of provision where you can do it yourself. But if you do not have the expertise to handle even the simplest of legal matters, because it's still legal proceeding, then you can get a legal practitioner who can and get it for you. And the legal practitioner here is not seen as a middleman, so to speak, as a process you must take. It is about legal representation only. So apparently you don't need any middleman or middle process or middle agency at all.
All right, the lines are open right now. If you'd like to join the conversation, you're very much welcome to do so. You can call 0700 923 0923. That's 0700 923 0923. A reminder, we're live on facebook.com/Nigeria Info PH. Join the conversation there as well. Also live on Twitter at Nigeria Info PH. That's at Nigeria Info PH via Twitter. Once again, number to call is 0700 923 0923. Would there be any fees or charges attached to accessing the services of the small claims court, Henry?
Yes, I expect that the minimal fees to be charged. Official fees for commencing actions are actually really not excessive, not high. So I expect that the rules will provide for minimal fees, processing fees to be paid, like every other action that is usually commenced in court. I expect that.
Well, I couldn't help but notice you said official fees. What do you mean by that? And does that suggest that there are unofficial fees?
Yes, I won't pretend that there may not be some attempts to extortion by certain individuals for every opportunity. So that's why I was emphatic about official fees. Even currently, all of the other methods of commencement of action in court, the rules of court provide for the fees payable to government. And they're usually not excessive, as a matter of fact. They said the professional fee you're paying to the professional who is handling your matter, but the official fees to pay are usually very minimal. That's it. So I think it was deliberate to distinguish that from anything anybody, by the way, say, hey, come down, you want affidavit? It's different. Like that cost of affidavit by the bus stop is different from the actual cost of affidavit that is official by court. So that's just an instance.
Well, by the way, as a slight or a further digression, this bus stop affidavit, Are they tenable in are they accepted in our courts?
Look, you see what actually happens. It's not the document itself that is not genuine, but I think it's the procedure and the racketeering around it. So what I think I observed that happens is that those agents get you accepting them to handle it for you. So as a matter of fact, they go process it in a normal way that it's thought to be processed and get the appropriate commissioners for all to get it commissioned, really. Because otherwise, if it's found that it's not properly commissioned, it is a criminal offense in itself. So, but that practice is not acceptable by God. It's condemned because it's not a process that should be done by anybody. But don't permit me 1 minute. Affidavit must be done as provided by the Evidence Act, meaning that ideally you must follow the law as it is. The commissioner for oath must even see the deponent. That is the person, the commissioner for oath that will commission the affidavit, must see the deponent. You do this, you swear to this oath. It's an oath. You swear to this oath before the commissioner for oath. So a situation where somebody at the bus stop around the court area flags you down and you stop and say affidavit, and then you give him all of your details and you give him the money, and then he goes to process it and later brings it to you. Ideally, that shouldn't even be what the Evidence Act really envisages, and even the Oath Act.
Go.
Yeah, Patrick from Moji.
Go ahead.
Good afternoon, Patrick from Moji.
Go ahead.
Upon conviction, can somebody be sentenced for any imprisonment, or can somebody appeal after conviction? Can somebody appeal after conviction?
All right, Henry. Question is: can a person, the defendant, I suppose, can the person be sentenced by a small claims court? I think he means sentenced to time in jail, and also, can an appeal be filed against the decision of a small claims court?
If it's from me, it didn't seem to come clearly, Dio. Sorry about that.
Okay, I think the question is, two questions he asked. One, can a person be sentenced to jail time by a small claims court? And then two, can an appeal be filed against the decision of a small claims court?
Yes, it's appealable. Like I said, there are two levels to it. It came down to me even from the soundbite. It appears that there will be the magistral level, and within 30 days, the matter must be determined, and thereafter it can be appealed, but its appeal court is the Court of Appeal. I mean, the High Court. The High Court could play a court of original jurisdiction and of an appellate jurisdiction. So it can take appeals from magistrates' court, so including the small claims court, if it commenced at a level that is the magistrates' court level. So it's appealable.
So how does that help how does that help the expeditiousness of this and the process if we still have to go to maybe a high court, for example?
It does help. The idea of appeal is not to suggest that matters cannot be determined at the magistrate level. It can be determined at the magistrate level, and the decision may be acceptable by parties. But if for any reason any person is dissatisfied with the outcome, at least there should be another level that you can ventilate your dissatisfaction to the decision of the first court of first instance. And then that's why the time is placed there, Dio. That is expeditious. Doesn't mean that you cannot have regulations as to time. And that's why it said, even if it is on appeal, that the High Court must determine that within the threshold of the time, beginning with the time that the complainant or claimant have filed the suit at the magistrate court, it must not exceed 60 days. Meaning that the magistrate court may have a maximum of 30, and the appellate court, which is the High Court, may have a maximum of 30 again. So if you put all together, it's 60. It's not that it's going to have another 60 days. That's one. But like I said, the matters can be determined at the magistrate court level at the first instance. And it therefore also means that there may be jurisdiction that the High Court may have original jurisdiction over small claims cases as well. But the other question was about whether there is a punishment.
Whether a person can be sentenced to jail time by a small claims court.
No. There is no punishment in civil proceedings. And that's why I took time to distinguish that this kind of court is appropriate and suitable for civil claims and civil actions. And I think that's what the court is intended to really be. So once it is a civil claim, there is no punishment. That's the difference between civil law and criminal law. So there isn't going to be any punishment for somebody who is owing you money. And that's how we got it. So you see where somebody is owing another money when you know that you actually got into commercial transactions. You run to the police, and then some of my colleagues, including some businessmen themselves, by themselves, do petition to police. So you don't have to arrest a person or get to the police to criminalize a civil action, purely civil action that you know of the truth that is civil. So there is no punishment as to term of imprisonment or even fine in civil actions. The punishment that you may suffer, if at all in any way, is that you probably will be ordered to pay some damages to the claimant in civil actions. So there's an advantage to it, to the claimant, and then some kind of detriment to the defendant. Because if the person was owing you 1 million naira, you had written a letter of demand to this defendant to pay your 1 million naira. He refuses, probably with impunity. And then it costs you to take some steps. Maybe you have to get a lawyer, and you're going to pay legal fee to the lawyer. You're going to pay these filing fees, and you're going to spend some time in court, even if it is 1 week. You have the right to also claim damages against that defendant. So at the end of the day, if the court finds in your favor, you may be getting like 1.2 million, 1.3 million, instead of the 1 million the person is owing you. So that comes as a detriment. The extra 200,000 comes as a detriment to the defendant who was recalcitrant and refused to pay his debt at when it was due.
All right, once again, number to call 0700 923 0923. That's 0700 923 0923. You can also join in via Facebook, facebook.com/Nigeria Info page. You can join via Twitter at Nigeria Info page as well. Via Facebook, Equity Yinda goes, good afternoon, Dan. The small claims court establishment is a good one, really, trust me. But my question remains, can an average Nigerian get justice with the accordance of the law? I hope and pray for better Nigeria. I hope justice prevails all round. Now, well, Equity Yinda is concerned. Okay, you'll respond to that in a moment. Okay, let's take the question now. He's concerned about, it sounds good, and it does sound good, no doubt, I believe, to everyone who hears it, but he's still concerned as to whether or not justice, will be got at the small claims court. Do you foresee any challenges with the small claims court?
Yes, there may be challenges. There may be challenges as perceivable from every system, especially in the beginning. There may be some challenges of access, and there may be some challenges of, especially where self-service is allowed here, the expertise. Yesterday I was in a court, and I asked a colleague in court, I said, do we really, when I observed the matter that was going on, and I asked a colleague, do we really get justice even through the judicial process and judicial system? Because when I observed truly, I think the error there was the witness in the witness box didn't seem to understand the question that the smart lawyer was putting across to him. And then that's it, and that's the rest, code of record. So whatever he said was taken as part of the record, and it could not be favorable to him. That individual will come out and say he didn't get justice. But justice here, as I believe that when you have access a bit expanded, then you have some form of justice, where ordinarily you wouldn't have been able to access the regular courts at all for certain reasons of cost and time and delays. Then now you have an opportunity that has opened a bit wider the window to justice, that is access, that is the justice relatively. Then the cost aspect of it, I haven't known now. We are watching to see what the cost will be. Because if these are small claims and somebody is going to be asking for 1 million naira debt, how much is it going to probably give to the state in terms of processing fees and legal statutory fees? These could be obstacles, could be challenges to justice. But I do think that the scale will tilt more to the side of justice than injustice by this kind of introduction of a specialized court. And that's why it's conceived that specialized courts should, in a way, relax the complexities of the law and evidence, so that persons who probably are not that quite experienced in law and evidence can also still get justice.
All right, Henry.
There will be some challenges, but largely I think there will be justice.
All right, Nwago Johnson from Eched. Nwago, you're welcome. Go ahead. And welcome from a chair. You're welcome. You're live. Go ahead, please.
Hello.
Go ahead.
My question is this. If the person is not satisfied, where does he go again?
Well, that was discussed a while ago when I asked Henry if the matter can be, if a decision can be appealed, and he said yes.
Yes, it can be appealed to the highest level. Am I heard?
Yes, Umago, if you're listening via your radio set, that was addressed a while ago. I did ask Henry that question as to whether or not the decision of a small claims court is final or it can be appealed, and he said it can be appealed. But when the rules and practice directives of the small claims court are determined and released, we'll have a clearer perspective as to what the mode of appeal or form of appeal could possibly take. But it can be appealed, at least that's the information available thus far. Once again, 0700 923 0923, number to call. Join via Facebook and Twitter at Nigeria Info PH. Chris sent this in. What if in the case of civil matter, what if in the case the civil matter is ongoing, then a defendant attacks the plaintiff? Of course, it has become a criminal matter. What then can be done? Henry?
Now,
What if a civil matter case is ongoing, then the defendant attacks the plaintiff? Of course, it's become a criminal matter. What then can be done?
Oh, actually, in legal practice, criminal action and civil actions can run concurrently or simultaneously at the same time, but at different courts and different instances. The scenario is clear. The civil action that someone was owing you and you've gone to court and you're seeking redress in that is completely different from that criminal conduct of that individual. Even if it's connected to the fact that you probably went to demand their money from him and then you file the suit and he gets angry and waylays you on, that's purely a criminal action. And my advice would be, criminal actions are commenced by complaints to arresting authorities, to the police. That is where you have the right to then go to the police. So if for any reason the defendant assaults you or threatens you or does any of those elements of crime, you go to the police and institute that complaint, and that will be a different case. The police will arrest that individual, investigate thoroughly and dispassionately. If there is reason and evidence to prosecute, they will prosecute him in another court in another matter, and that's where he will be punished by the question the other caller or person probably asked, where you could either be sentenced to a jail term or some fine to be paid.
Once again, any questions or thoughts, comments on the Rivers State Judiciary Inaugurating Judicial Committee on Small Claims Court? Let's get to your thoughts now. Your questions, call 0700 923 0923. That's 0700 923 0923. Or send in your comment or question via facebook.com/Nigeria Info PH. We're live there at the moment. Also via Twitter at Nigeria Info PH as well. Let's talk about the matter of self-representation. Henry, could you expatiate on that? What exactly does that entail, self-representation?
Okay, what I mean is that every citizen has a right to defend himself in person, right? Even constitutionally, it's a constitutional right, or you have a choice to have a legal representation by a legal practitioner. So this particularly, that creates some sort of a wider opportunity for self-representation is because of the simplicity of the practice and the procedure and proceedings in this kind of specialized court. But what it means is that the ordinary businessman who probably has got into some contract, whether it's a contract of sale or any other form of contract with any individual, and the person has breached the contract, he can by himself approach the court and then seek to defend himself. And I think this quite is expanded resemblance to the Judge Judy's case, where you don't have much of lawyers representing these individuals. And I think that is a similar one that is going on DSTV2 here in Nigeria. The individuals are there, and then you can simply represent yourself and make your claims. If you need for any reason to cross-examine the other person, you could ask the person the questions you would have desired your lawyer to ask. And because of the simplicity of the process and then the relaxation of rules of evidence and actual legal complexities, I think individuals can conveniently represent themselves. But what self-representation means is that you may not need a lawyer to do your case.
All right, Henry.
In this court.
We've got Wilson from Woji High. Go ahead.
Hello, good evening.
Go ahead, Wilson.
Okay, I'm Wilson. I'm calling from Woji.
Go ahead, Wilson.
All right, what I wanted, nice, which they are introducing, but the problem that with, just like previous callers have said, in case money expect
Wilson, I apologize. I can't make out what you're saying, really.
So if we check from the money that is bring you to invest more of it, you will fail a lot. It's supposed to mention, the amount of the money that we are going to spend, so that it will be easy for anybody that is going there. Because this is one of the problems that we have. Just like what the man that is analyzing was telling us. Yes, you will go there because you don't know the procedure. The person that is in charge there now be able to maneuver. So we are a novice to maneuver us and say this money or that money. Who do you complain to when it's like that? Thank you. That's my question. Thank you.
Okay, I'm not sure that's a very big challenge. I mean, I don't think. I mean, it's like when you go to the courts, I'm sure there are processes there. I'm sure that receipts are issued for monies paid. I'm sure. But Henry, a quick word on that as we wrap up the conversation, please.
Oh yes, like I said earlier, if I got that clearly, what will constitute the fees to be paid officially will come with the rules, and I expect that to be minimal. Then the need to know what fees you're likely to pay, so to determine whether you're even going to pursue that cause or not. I think it's very important, and that's why I believe, looking forward, that when this whole work of the committee is concluded and then the court is inaugurated and the rules and practice direction are made public, because it is one court that is targeted at a greater proportion of the population, the online, there should be so much of publicity and
Henry, I'm sorry, but we have to wrap this up now. But very quick question, very quick response, please. Hello, there. Can the landlord use this court for eviction of a tenant?
No. This is not recovery of premises. There is already a procedure and a law for recovery of premises. No, it's not.
All right. On that note, we have to wrap up the conversation. Thanks for joining in. Especially thanks to my guest, Henry Ekine, a lawyer. He's National Legal Advisor with the Committee for the Defense of Human Rights. Henry, many thanks for your time.
Thank you, Dayo. Quite appreciate the opportunity.
Commercial break. We've got news update for the hour at 5 o'clock. I'll return afterwards. And House of Reps resolves to investigate activities of mobile application lenders. Michael Ogba, CEO of Sitiamo Technology Limited, joins me for that conversation. Do please stay with us.
The show we all have that one friend that always hides everything from everyone else.